Welcome to Chapter 15, our last chapter in judicial process. Let's finish up by discussing the Supreme Court, the justices, and their decisions. In this chapter, we'll address selecting justices, Senate confirmation, the decision-making process, the justices' policy preferences, the court from Warren to Roberts, and the impact and implementation of Supreme Court decisions. Presidents believe the Supreme Court justices are among the most important nominations they will make in their presidency. Presidents can leave an enduring mark on the U.S. legal system by the justices that they choose. President Donald Trump chose 3 justices at the Supreme Court and hundreds of justices at the District and Appellate Court, and will have a big impact on the judicial system for years to come. The president, however, has no control over the timing or frequency of vacancies on the Supreme Court. The nomination process is technically guided by the same process as all other federal judges, which is Article 3 of the United States Constitution. The president nominates, the Senate confirms through advice and consent, and they are lifetime appointments. In reality, the process is very different. Presidents take great care in selecting Supreme Court justices and often get personally involved. Presidents vary in their level of involvement, but generally speaking, the president takes top priority in the nomination process. The most influential selection criteria for any one nominee is merit, personal and political friendships, policy preferences, and symbolic representation. More than one of these factors will be at work in any one nomination, and the president will vary in their level of commitment to the criteria above. Presidents seek nominees who are qualified jurists. A majority of justices had already achieved eminence by the time they were selected in judicial, legal, or public careers. Some challenge this view today and question the eminence of the current justices prior to their appointment. For instance, in 2005, 8 of the 9 justices had previously served on the U.S. Court of Appeals. Table 15.1 shows Supreme Court justices in order of seniority. This table is outdated. We don't have a current table for this slide. You can see that Chief Justice John Roberts has been on the bench since 2005. Justice Antonin Scalia died a few years ago and was replaced with Justice Neil Gorsuch. Justice Anthony Kennedy has retired and been replaced with Justice Amy Coney Barrett. Justice Clarence Thomas is still on the court as of since 1991. I'm sorry, Anthony Kennedy was replaced with Justice Brett Kavanaugh. Justice Clarence Thomas is still on the court as of since 1991. Justice Ruth Bader Ginsburg died in the fall of 2001 and was replaced with Justice Amy Coney Barrett, in the fall of 2020 and replaced with Justice Amy Coney Barrett. Justice Stephen Breyer is still on the court, though he is also retiring. He recently, in the spring of 2022, announced his retirement and will be replaced with Justice Ketanji Brown Jackson. Justice Samuel Alito has sat on the court since 2006. Justice Sonia Sotomayor has sat on the court since 2009. Justice Elena Kagan has sat on the court since 2010. Personal and political friendships factor heavily in criteria for nomination. Historically, 50% of justices have been personal friends of the president. 90% of justices have been from the president's same political party. More recently, presidents have moved away from appointing personal friends to the court to avoid the appearance of favoritism for political purposes. Policy preferences factor greatly in nomination criteria. Modern presidents seek nominees who share their policy preferences. Some presidents are more committed to ideology, like Ronald Reagan and George W. Bush, than others. George W. Bush than others like Bill Clinton or George H.W. Bush. And frankly, I think that point is not well made. Presidents are across the board committed to ideology, and so some may be more ideological than others, but there's no doubt that policy preferences play a key role in their selection of Supreme Court nominees. Once on the court, some justices reveal policies different from their appointing president. Research demonstrates that typically presidents and justices agree for many years on important policy issues. Another criteria for nomination is symbolic representation. Symbolic representation is very important, and so symbolism could include geography or religion, race or ethnicity or gender. In the 19th century, geography was more important than it is today. Religion has been an issue, where today, at least as of the date of this slide, creation, 5 of the 9 justices were Roman Catholic. And I believe that today that number is more. It's 6 to 7 of the 9. Only one woman at the time of this slide, Ruth Bader Ginsburg, served on the court. And today that's Amy Coney Barrett, who replaced Ruth Bader Ginsburg. And it's also soon to be Judge Ketanji Brown Jackson. We also have Judge Sonia Sotomayor and Judge Elena Kagan. Interest groups play a big part in the criteria of nomination. Interest groups are now actively engaged in the process. Some senators object to the attention and the pressure that comes with court nominations. Historically, the American Bar Association was very powerful, with presidents even submitting potential names to the ABA prior to making any announcement. Today, the ABA is treated the same as any other interest group. The Senate is given confirmation authority in a nomination process. The president is constrained because the Senate must confirm the nominee. Once the nomination is announced, the Senate Judiciary Committee holds hearings and questions the nominee on many issues. During the hearings, other experts may also testify about the philosophy and the credentials of the nominee. After the hearings, the Judiciary Committee of the Senate votes and makes a recommendation to the full Senate. Most nominees are supported by 2/3 or more, and nominees are confirmed fairly quickly. The process has become more political over the years during recent nominations. Since 1968, there have been a series of controversial nominees. 2 factors have been important: policy preferences, which we saw in the nomination of Robert Bork in the 1980s, ethics and competence issues, which we saw in the nominations of Fortas and Hainsworth, Carswell and Douglas Ginsburg, and Harriet Miers. Senate confirmation votes appear to be increasingly political, corresponding to the political culture of the states. Presidents can avoid controversy by choosing nominees with broad political and senatorial support from the opposing party. Nominations can be particularly contentious when the nominee's policy preferences differ from those of the retiring justice. So, for example, a conservative Samuel Alito who replaced a rather moderate Sandra Day O'Connor, or more recently, a conservative Amy Coney Barrett who replaced the liberal Ruth Bader Ginsburg. Once a nominee is confirmed, attention shifts to predicting how the justice will vote. All justices experience a transition to the court's practices and procedures, the norms of the court, as they say. And this shift, this new nominee, requires learning to write opinions and interact with colleagues and manage their own chambers. The decision-making process includes briefing. After a case is accepted by the court, both parties prepare written briefs setting forth the legal arguments in the case. The briefing offers a position and provides legal evidence and justifications to reach the result needed or wanted by the party. The court limits the length of briefs to 50 pages, or 30 pages for an amici curiae. The decision-making process also includes oral arguments most of the time. Time for oral argument is strictly limited to 30 minutes for each side. However, the court has pushed the boundaries more recently through lengthy questioning. Lawyers come prepared to present their case, but justices frequently interrupt to ask and answer questions. Attorneys may focus their remarks on a key justice to win a victory, and justices may ask questions they want their colleagues to hear. After the oral argument, within days of the oral argument really, the justices assemble behind closed doors in private to discuss the case and take an initial vote. The Chief Justice discusses the case first, followed by the associate justices in order of seniority. At the end of the discussion, the Chief Justice tallies the votes, the original vote of the merits. Discussions in conference are private, but we know they are less freewheeling than they used to be. The briefs and oral arguments and discussion with the clerk leads justices to a pretty firm opinion in advance of any conference. Conferences serve to discover the consensus among the judges. After the vote, the Chief Justice, if in the majority, assigns one justice to write the majority opinion. If the Chief Justice is in the minority, the most senior justice in the majority assigns the opinion. The opinion assigner can assign the opinion to any justice in the winning coalition, including him or herself. Assignments are based on workload, ideology, specialization, and self-assignment. Equality of workload is an important rule, and recently the median opinion assignment is 8. When a court looks at assigning it, or when a judge assigns an opinion, they also look at ideology. So in a minimally winning coalition, like 5-4, choosing a justice near the middle may keep the coalition together. Justices are free to change their mind at any time before the public announcement of the opinion. Justices develop certain specializations, in particular areas of law, and opinions in these areas are often assigned to them based on this reason. There is a tradition that the Chief Justice assigns himself the most important cases. Slotnick has found that 25% of the opinions in important cases were authored by the Chief Justice. Writing opinions is the most difficult and time-consuming of all judicial tasks at the Supreme Court. Research shows that justices write opinions strategically, so they will attract sufficient justices to win the case and influence the law. Law clerks are very involved in helping draft judicial opinions. Once the justice prepares a draft opinion, it is circulated to all the other justices. The justices may sign on to the opinion, suggest changes and revisions, or decide to strike out on their own and write a separate opinion. Research shows that important interaction takes place during this give and take. Multiple drafts of opinions are not uncommon, and sometimes opinions answer questions not directly raised in the case. This is referred to as judicial fluidity. The announcement of the opinion. The court decides every case argued for that term, and when the opinion is ready, it is announced from the bench and copies are distributed to the public. Many of the decisions come at the end of a term, as many as 6 in one day. In an opinion of the court, a majority of the justices agree on the result in the case and the legal reasoning for the outcome. If no opinion is joined by 5 justices, the opinion with the greatest number of signers is referred to as the plurality opinion. A concurring opinion is issued when a justice agrees with the result, but not the legal reasoning. If a justice disagrees with the court's decision and legal justification, he or she may write a dissenting opinion. The Supreme Court is characterized by division rather than consensus. Disagreement on the court among the justices has led political scientists to ask why judges disagree and to try to explain the variation. Pritchett in 1954 urged us to consider the thinking of individual justices and focus on the question of why do justices vote the way they do. Generally, political scientists believe that justices vote their attitudes. Such votes allow them to pursue their policy values. Policy preferences are translated into votes on cases that shape legal doctrine. A variety of methods are used by political scientists to study the votes of justices: block analysis, attitudinal models, strategic models, and the legal model. Block analysis examines the patterns of voting among the Supreme Court justices. For instance, during the 2013 term, Thomas and Alito voted together in 96% of cases. Another way to examine blocks is to look at coalitions. During the 2013 term, Roberts, Scalia, Kennedy, Thomas, and Alito voted together in 4 out of the 10 cases decided by a 5-4 vote. Table 15.3 shows a percentage of agreement in votes between U.S. Supreme Court justices during the 2013 term. The attitudinal model assumes that justices vote are a function of their policy preferences. One difficulty facing this model is how to measure policy preferences. Justice Scalia votes in a conservative direction in 70% of the cases, but is he ideologically conservative? Occasionally, justices cast votes that are inconsistent with their ideology. This is where additional explanations are important. The strategic model assumes that justices are policymakers who act strategically to achieve their most preferred outcome. Acting strategically may mean not voting for your most preferred position when a vote for your second or third most preferred position will result in a better outcome. The strategic model is very intuitive, but it adds substantial complexity to explaining judicial behavior. However, the strategic model has become very popular among political scientists. The legal model asserts that justices decide cases by the product of the legal statutes involved. This is the preferred explanation among many law professors. This does not allow for policy preferences in the model, and recent twists have argued for jurisprudential regimes which include a key precedent which impacts other cases in particular legal arena. Let's talk now about the Supreme Court from Warren to John Roberts. Scholars and journalists often refer to the court by the name of the Chief Justice. Between 1953 and 1990, the Chief Justice was in the majority 80% of the time. There have been 17 Chief Justices in the court's history, and one of the most important positions in the United States political system is Chief Justice of the Supreme Court of the United States. The Warren Court was from 1953 to 1969. That's a typo. It's not 1069, but 1969. And it's known for its decisions in the era of civil liberties and civil rights. The Warren Court revolutionized constitutional law and the United States society. The number of civil liberty cases increased every year during this term, and during the 1968 era, Richard Nixon ran for president, criticizing the court as being soft on crime and moving too fast on civil liberties. The Burger Court was the court where Nixon appointed 4 justices, including naming Warren Burger as the Chief Justice. The Burger Court from 1969 to 1986 is known as a more conservative court than the Warren Court, but not for constitutional counter-revolution. Many on the Warren Court set precedents that were upheld. The Burger Court was characterized by pragmatism and compromise. The Rinquist Court from 1986 to 2005 had been successful in cementing conservative principles in legal doctrine. A firm voting bloc of 5 justices, William Rinquist, Antonin Scalia, Clarence Thomas, Anthony Kennedy, and Sandra Day O'Connor, decided a large number of cases. One observer characterized this era as a clear break from a time when the court was an engine of social change. Interested in curbing federal power and leaving most matters to the states, the Rinquist Court was most clearly aligned with conservative principles in legal doctrine. Since 2005, we have had the Roberts Court. The addition of John Roberts as Chief Justice and Associate Justice Samuel Alito, who replaced Sandra Day O'Connor, and since then, the replacement of Antonin Scalia with Neil Gorsuch, of Anthony Kennedy with Brett Kavanaugh, and of Ruth Bader Ginsburg with Amy Coney Barrett, means that the court promises to bring additional ideologically conservative decisions. Roberts joins the court with impeccable legal credentials, setting the bar high for the next nominee. John Roberts was young when he was appointed, and the impact of the Roberts Court will be felt for many years to come. The impact of the court's decisions is a function of the level of their implementation. The court has neither the power of the purse nor the power of the sword. At times, implementation has been slow and frustrating, and other times it's been fast and immediate. The Supreme Court is rarely the last word on these matters. Instead, its impact and implementation are affected by how the core institutions respond. Congress and the President, governors and state legislatures may embrace the decision, or they may reject it. If the decision involves a constitutional matter, the Congress may try to change the Constitution by amendment or engage in retaliation against the court, such as changing its jurisdiction or slowing the salary increases. Impact and implementation also depend on how the rulings are interpreted by judges and lawyers. Lawyers may continue to file cases asserting that certain legal principles have not been addressed, or may embrace the court's interpretation of a legal doctrine. Federal judges are required to follow precedent or stare decisis, but often the case facts present a slightly different situation than was presented in earlier cases, leaving an opportunity for viewpoints to diverge. The users of a legal system are also important. Interest groups have a willingness to embrace a new legal doctrine or change to the current legal doctrine, make it more or less likely that the impact of the court's decisions will be widespread. The court's decisions, while definitive, still remain vague regularly, leaving considerable room for users to make decisions about how to interpret the court's legal statements. Ultimately, societal values and cultural norms determine the impact and implementation of the court's decisions. Public confidence in the court is important, and the court has historically paid attention to its public standing. Overall, court decisions are rarely out of step with the basic cultural and social views of a majority of the country. In conclusion, the Supreme Court is the most powerful legal institution in the world. Justices are nominated by the President and confirmed by the Senate. Justices are picked for a wide range of reasons, including policy preferences and demographic factors. The opinions of the court come after considerable deliberation, written briefs, oral arguments, conferences, opinion drafts, and final opinions, and find their way into the implementation of the laws of the United States of America, ostensibly for the good of America. Membership on the court is prestigious, and it's limited to a very few select lawyers. Judicial decision making is characterized by attitudinal, strategic, and legal models. Justices show tremendous stability in the ideological direction of their votes and the coalitions they join, and the impact and implementation of the court's decisions involve core institutions, the interpreters and consumers of the law, and is influenced ultimately by the political, social, and cultural values of the country.